This is Democracy Watch. Mark, this is a really important episode because we have something imminently coming up that I think everybody should be paying attention to that is not getting any coverage. Can you explain what's about to happen at the Supreme Court and why everyone needs to be paying attention to this?
Yeah, Brian, we've done a lot of videos, but there perhaps has not been a more important one than this. So I want to start by asking everyone to do me a favor and subscribe to this channel and hit the bell in front of you to stay informed when new episodes are posted, because the Supreme Court is about to hear oral argument in a couple of days in a case out of Louisiana that will literally decide whether the Voting Rights Act remains in good law and remains a protection for minority voting rights, prevents Republicans from redistricting themselves into permanent power in the House of Representatives, or whether the Supreme Court backs away from that, says, you know what, the times have changed, no more protection for minority voters, and no constraints on Republicans in the Deep South to engage in absolutely horrific wholesale gerrymandering. This is a five-alarm fire. I mean, you know, if there is any case in America that you, the audience, need to be paying attention to and you need to be really, really engaged in, it is this Calais versus Louisiana. It is something that Brian and I have talked about before. It is something we are going to talk about moving forward. So please do me a personal favor. Subscribe to this channel. Hit that bell, because it is vitally important for you to understand what is going on in this case in every step of the process moving forward.
So let's talk about the practical implications of what happens if the Supreme Court decides to gut what's remaining of the Voting Rights Act. This is Section 2 of the Voting Rights Act. This involves the preservation of majority black districts or opportunity districts, as they're called. What happens if the Supreme Court decides to gut what's left of the Voting Rights Act to those existing opportunity districts across the country and states across the country?
Yeah, so what people need to understand is when we talk about Section 5 and Shelby County, this is the case from 2013 that people were very upset, correctly upset, as gutting a key provision of the Voting Rights Act. That provision applied only to states with histories of discrimination in voting. What it basically said was those states couldn't change their voting laws without getting pre-cleared those changes to make sure they didn't disadvantage minority voters. But there was another provision. And in fact, in Shelby County, the Chief Justice cites this other provision, Section 2 of the Voting Rights Act, as applying nationwide. And what it does is it prevents vote dilution of minority voters' votes everywhere in the country. And it has particular application in the redistricting context. What it basically does in the redistricting context is says that white legislatures, Republican legislatures, cannot divvy up black voters into a variety of districts and therefore deprive them of their ability to elect candidates of choice, particularly in jurisdictions where that kind of behavior has gone on before. The net effect of that has been that throughout the Deep South, but also, as you point out, not in the Deep South, in states around the country, Native Americans in some places, Hispanics in places like Texas, have been protected from these kinds of vote dilution tactics. Well, if Section 2 is struck down, what it means is that Texas will be able to go back and redistrict again and destroy a bunch of districts where right now black voters and Hispanic voters are able to elect their candidates of choice. It means in Alabama and Louisiana and in Mississippi and in Florida and in Georgia and in South Carolina, just to name a few of the states, the districts that have historically been created to protect black voters from, again, being diluted, hither and yon into various districts and losing voting power. Those districts would no longer be protected under federal voting rights law. It could have a swing on the partisan level of 20 or 30 districts. On the black and Hispanic representation level, it would be even more devastating and could have catastrophic effects. So this is really the whole ball game as you look at cases pending before the Supreme Court this term. This is the one to pay attention to. And as I mentioned, Brian and I have talked about this before because this case was argued once before in the Supreme Court. It was argued last term in the Supreme Court, and we expected initially the Supreme Court would give it the back of the hand. Then as the term went along, we got more and more nervous because the Supreme Court hadn't ruled in it. Well, at the end of the term, rather than deciding the case, they scheduled it for rehearing. And that rehearing comes up this week. So please pay attention to this case.
And I should also note that you have been doing excellent coverage, relentless coverage of this particular issue, among other issues. So if folks who are watching right now are not yet subscribed to Democracy Docket, that's Mark's news outlet that he focuses on everything voting and elections, please subscribe, because that is the best outlet to follow along with this stuff as it continues to break. Mark, the fact that the Supreme Court decided not to rule on this case, not to give it the back of the hand like we expected that they would, and for them, without even being asked by the parties to rule on this particular issue, this was just about one seat in Louisiana. And instead, the Supreme Court came forward and said, you know what? In fact, let's just hear a case on the merits of Section 2 of the Voting Rights Act altogether. Does the fact that they asked for that without being asked to hear this case, the fact that they did it unto themselves, does that suggest that they may be more inclined to rule against Section 2 of the Voting Rights Act?
Yes. And I wish the answer were no. But, one of the things, Brian, when you and I started doing this series, we made a deal with one another and with you, the members of the audience. We're always going to tell it to you straight. We're not just going to give you the happy news. We're going to give you the straight news. And the truth is, this is not good news. Now, it doesn't mean all is lost. It doesn't mean that the case can't wind up in the right place with Section 2 surviving. But let's be clear, the fact that the state of Louisiana did not come into court initially and say Section 2 is unconstitutional, that actually the white plaintiffs who brought this case did not come to court, to the Supreme Court, saying, please strike down Section 2 of the Voting Rights Act. And obviously, the parties defending the case didn't. The fact that nobody came to the U.S. Supreme Court asking that this question be decided, but that after the case was argued, that the Supreme Court on its own asked the parties to brief and argue this case, that is an ominous sign. Again, I don't want people giving up hope. I don't want people thinking that all is lost, because, the lawyers fighting this case, including some lawyers at my firm, they are fighting every day for what's right in this case, and they may very well prevail. But we should be very clear-eyed about what we're up against here, which is a Supreme Court that decided it wanted to hear this question. And by the way, if you ask me the last time this happened that I can remember, it was a campaign finance case argued in 2009, set for re-argument in the fall of 2009, that was decided on January 10th, 2010, and that case was Citizens United versus Federal Election Commission.
Right. And that the parties did not come in asking for Citizens United to be argued. And what we got instead was a case that had cataclysmic impacts on our campaign finance. From my vantage, and I think most people watching who aren't attorneys or involved in the intricacies of what goes on in front of the Supreme Court, we see these cases that are very partisan, and we just assume, I think, that most of the results here are just preordained. That if you have a 6-3 court, that on issues where most Republicans are going to agree, it's just going to fall on partisan lines. And so I'm curious from the perspective of someone who himself has argued in front of the Supreme Court, how important is lawyering in these cases versus just, the partisan composition of the court and arguments be damned?
I think lawyering matters a lot in the Supreme Court. I think it matters a lot at the trial courts, and then it matters a lot in the very high-profile cases of the Supreme Court. I think in between, it still matters, but I think it really matters in these high-profile cases, and here's why. Because the court may have a sense of where it wants to go, but good lawyers are going to lay out what the consequences of that are. In other words, they're not just making the legal arguments about what the constitutional history is, what the law is, what the precedent is. Lower courts have to follow precedent. The Supreme Court can do whatever it wants, right? It doesn't have to follow its past precedent. As we've seen, unfortunately, it can overturn those precedent. So one of the things that's different about arguing for the Supreme Court, and as you point out, I've argued 4 cases in the Supreme Court, and I've won 4 cases. I'm arguing another case that I'm sure we're going to talk about when it gets closer this December before the Supreme Court. So I've started getting my head in that case. And what you realize that's different about the Supreme Court is that the justices can go in any number of ways that lower courts can't. And so as an advocate before the Supreme Court, trying to put together a coalition of at least 5 justices, you're trying to figure out what are the things that are going to cause individual justices to think, you know what, doing this thing in the abstract may seem like an okay idea, but actually it creates doctrinal problems, or it creates practical problems, or it creates jurisprudential problems, or standing problems, or justiciability issues, or unforeseen consequences. And so a lot of the lawyering that goes into particularly oral argument is trying to frame these questions and help the justices that are undecided on this think through what happens if you actually do this thing. And you can wind up, as a result, going in with a case you think is going to lose and wind up winning, or vice versa. And I'll give you a few examples. I wound up, the cases I won were redistricting cases. They were cases involving protection of minority voting rights. And, in a couple of those cases, I think we went in and people thought it was a long shot to win. We wound up winning, and we wound up actually winning some conservative justices, because I think they understood that what I was arguing, was kind of sort of fit more neatly in a long range jurisprudence rather than maybe a short term jurisprudence from their standpoint. We saw this in a case that one of my partners argued out of Alabama, which also was a Section 2 Voting Rights Act case involving redistricting, right? That created a second Black Alabama congressional seat or Black Opportunity District. And again, I think you would have gone into that argument thinking, well, they're not going to prevail because the Supreme Court is hostile to Section 2 of the Voting Rights Act. By the way, it was this Supreme Court. It was the current composition. But I think as you watch that argument unfold, you could see the court think, okay, actually, given the facts of this Alabama case, we really can't get where we want now. The bad news is they're back now with Louisiana. But, those kinds of things can happen. The last case I'd mention is the Moore v. Harper, which was the redistricting case out of North Carolina, where really everyone thought that we would watch the Supreme Court adopt the fringe independent state legislature theory. Again, there my law firm represented Becky Harper, the lead plaintiff, or the lead plaintiff below, and then the respondent in the Supreme Court. And again, you saw the conservative justices who may have had an interest in ISL. Who knows? But as the case was argued, they could see how, that where they were being led to is a place that honestly they were just never going to wind up, which is that state courts can't apply their state constitutions.
Yeah.
So don't lose hope that there can be a victory even in these really hard cases. Now, I want to be clear. Don't blame the lawyers if they don't pull a rabbit out of the hat.
Yeah.
But don't give up hope that the arguments here may matter.
And finally, let's finish off with this. As you mentioned, the arguments are on October 15th, which is early in this Supreme Court term. Yeah. When can we expect some type of ruling from the Supreme Court? I know that you can't pinpoint a day, but what's the range of when we can expect a ruling?
Yeah, so look, I think that there are two windows I'd be looking at. Okay. The first is early in the term. So think January or the first week of February. Now, why do I say that's the first window? Because if the Supreme Court wants to rule in time to affect the 2026 elections, it's going to have to issue a ruling in that time window, right? Now, that would be the worst of all outcomes, because one would assume that they'd be trying to rush a ruling quickly to overturn the VRA in order to allow states to draw new maps for 2026. And that would be that doomsday scenario that I laid out, where you could watch Republican legislatures around the country do mid-cycle redistricting and really tilt the playing field in unfair and terrible ways. The second window is the end of the term. Right now we're talking like June. Which is when usually the Supreme Court decides its biggest cases, right? Yeah. So in a normal circumstance, you'd say, if the Supreme Court was going to have something really important to say, either good or bad, right, on either side, if it's going to have a major ruling on the Voting Rights Act, you would expect it to come as among the last cases of the term in June. That's when the Alabama case was decided affirming the Voting Rights Act. That's when you saw the independent state legislature case out of North Carolina come, very end of the term. That's usually when we expect the most controversial and weighty decisions. I think that those are probably the two windows to watch. One would suggest they are trying to rush a decision because they want there to be the ability for states to react in time for 2026. The other would say, look, we're not trying to get anything done for 2026. We just think this is a very important issue. And so we'll decide it in June, and it won't have any impact, good or bad, for 2026. It will be something that would take longer to implement. As I mentioned, Citizens United decided in January of 2010, right, an election year. very early on. What you then saw was the application of Citizens United for the 2010 election cycle. And then those other cases I mentioned all came very late in the term and really had no impact for that election cycle.
All right. Well, obviously a lot to stay on top of here. Again, for anybody who's watching, there is no better coverage on this particular issue, or most legal issues, to be perfectly honest, than what Democracy Docket is putting out right now. So if you are not yet subscribed to Democracy Docket, please do yourself a favor, support fearless independent journalism and support the invaluable work that Mark and his team are doing by signing up. That link is right here on the screen and also in the post description. You can also find the link to this channel so you can watch more Democracy Watch episodes. That's on the screen as well. If you've not yet subscribed
and if you haven't liked the video, I mean, if you've watched the video and you like it, hit the like button. You know, it matters. It matters, you know, to the channel as a whole, but honestly, it matters to me and Brian. Like, I look to see, I read the comments, so you should also leave a comment, but I like to see, do people like what we're saying? Do they think what we're saying is useful or not useful? So you can leave a comment, but if you're not up for writing a comment, if that's too much, the least you can do is hit the like button if you like the video.
That's it. Completely free. I'll put those links right here on the screen. I'm Brian Tyler Cohen.
I'm Mark Elias.
This is Democracy Watch.